testing testing， 各位同事早晨，
Good morning, members. It's already beyond the starting time, and we have formed a quorum. Let's invite the officials to come in now. This is a meeting of the Bills Committee on Stamp Duty Amendment Bill 2013. I'm the chairman, and I would like to declare the following interests. I own the property, and I work for an accountancy firm, and among the clients there are people related to the provisions in the bill, but I do not work for them. Mr. Andrew Leung, I declare that I hold properties. Mr. Wang Tingguang, I would like to maintain the same declaration as before. Mr. James Toh, I also want to declare that my previous declaration still stands. Mr. Tony Chair, the same. Mr. Dennis Kwok, well, I hold properties. After the last meeting, the Secretariat issued some follow-up questions to the Deputy Secretary. I understand that some of those are related to principles, and the Deputy Secretary still needs some more time to finalize the position with the Bureau. So is that still the case? Thank you. Last time, members raised questions about certain figures and statistics and certain concepts and proposals. We're still working on the response. We will revert back as soon as possible. As for the, apart from the list of outstanding questions, Mr. James Toh also issued a letter dated the 24th of February, and we have yet to receive a reply. I believe the Bureau will revert as soon as possible. Yes, that's correct. Well, there are technical and political considerations involved. I hope the Bureau can come back to brief us as soon as practicable. In that case, let's return to the cross-by-cross examination. On the 14th of January, our legal advisor, or rather, the administration gave a reply on the 14th of January regarding questions raised by our legal advisor. I've asked the legal advisor that when we proceed to scrutinize the relevant provisions related to the questions he raised, and also the response given, a reminder will be given to members for information. All right, I think we can proceed to cross by cross. Last time we were at cross 29AN. The page number is 714. Mr. James Toh, you have some comments? Do we have something called annex? I think the Legal Services Division's document. As paper CB 11096 1314. Well, it's extracted by my secretariat staff. Is that the paper with the word annex? It's a paper CB 1096, CB 1096 1314 bracket 02. So you have this paper with annex, the word annex, issues, the administration's responses. Yes. Please find that paper if you want to know what issues were raised by our legal advisor and also the administration's responses. If I haven't got a copy, we have got some spare copies back there. Are we discussing this one? Well, we are going to do the cross-by-cross examination, and then if we move on to the clauses mentioned in the legal advisor's letter, we would give a reminder to members. 714, C714. 29AN and 29AO is so-called money for exchange, and and also how to pay the difference. In the 2012 bill, that is in relation to the BSD and special stamp duty, there are similar provisions. So if it's an exchange between a residential property and a non-residential property, and the consideration will be the difference of the values, and so the stamp duty will be charged on the difference. If the transferee is a permanent resident and is not a beneficial owner of any other residential property in Hong Kong, then the old stamp duty rate would apply to the difference. And we also have some provisions covering exchanges between close relatives. Whether the transferee is a permanent resident of Hong Kong or not, or whether he is a beneficial owner of any other residential property, the old stamp duty rate would apply. I'm sorry, I may have skipped this for some time. Are you talking about exchange with some preconditions? Well, it's just an ordinary exchange. So let's say person A, it holds a residential property, person B holds a non-residential property, and they, through an instrument, stamp duty instrument, exchange their properties. Under the Valorum stamp duty arrangement, the two have to pay a difference to make sure that the values are the same. And the stamp duty is imposed on this difference. It's called the equality money. So person A has a residential property, and he exchanges his residential property with another person's non-residential property, and the ad valorem stamp duty is imposed on the equality money or the difference. Yes. Let's say we have two properties. Property one owned by A and B, and property 2 owned by C and D. So if either one of them, one of the four, is not a permanent resident of Hong Kong, then the stamp duty applies to everything. Is this relevant? Let's say CD's property 2 is used to exchange AB's property 1. And if either one of the four is not a permanent resident, will the stamp duty be imposed on everything? Here we're not talking about close relatives. If A plus B exchanges with C plus D, and the transferee or transferees, let's say C and D, take on the residential property, the transferee all of the transferees must be Hong Kong permanent residents and must not be the beneficial owners of any other residential property. Let's say C, one of them, C or D, one of the transferees, is not a permanent resident. If they are, say, half and half, joined, they hold the property jointly, so the double stamp duty will be imposed on the entire property. Correct. If you look at 20 AN 3B, we are talking about there's a requirement that transferee or each of those transferees is a permanent Hong Kong resident and is not a beneficial owner of any other residential property in Hong Kong. I want to give an example. I hope the Bureau would consider the case. I know the ILD is aware of this and they are trying to help. A mother is a non-PR and the son is underage, a permanent resident but underage. They were given a flat by the HA, and under the tonnage purchase scheme, they purchased the PRH flat at a cost of $200,000. Since the mother is not a permanent resident, the son is a permanent resident, but under the 2012 bill, no trust is allowed because of the concern about loopholes. So none are eligible for the exemption. So under the previous bill, they have to pay BSD. And now under our bill, well, that case is a real case. I'm concerned that there will be a similar case like this in the future. So DSD will be imposed. So they purchase PLH, HA's PLH flat. So at the end of the day, they have to pay $70,000 in duty, in stamp duty, and they cannot take out a mortgage to cover the $70,000 stamp duty. So they were very upset, and now they are trying to ask the ILD to allow them to pay by installments. I understand the ILD is sympathetic, and the request is being considered. Well, I would support you as a matter of general principle. I said so in respect of the 2012 bill, and I would say the same for this bill. But you have to consider cases like this. These tenants were PRH tenants, and as sitting tenants, they are allowed to buy their PRH flat. And now, because of BSD and DSD, they have to pay as much as $70,000 in stamp duty. But you say that everyone should get equal treatment. But you have to remember that they are sitting tenants of housing authorities or public rental housing estates. So maybe some other considerations should be applied, because they are not like other people. They are not competing, so to speak, with other people for that particular PRH flat. The HA relaxed a previous rule that as long as half of the members of the family are permanent residents, they are allowed to buy the PRH flat given by the HA. We'll consider this case, but anyway, we would enforce the law faithfully. In your example, the case actually occurred. The mother is not a PR, the son is a PR but underage, and they jointly purchase. Well, it's a nuclear family. With the 2012 stamp duty ordinance enacted, and the amendments moved in the bill. If someone is acting on behalf of a underage PR, then BSD will apply. But we have no similar provision here in this 2013 bill. Our attention is on the status of a beneficiary owner. So if the mother is holding the property on behalf of the PR, then the old rate applies. But one of them is not a permanent resident. And now for this flat purchased by the two of them, half is owned by the mother, and the other half is owned by the son. And the stamp duty applies to the total consideration of the threat.
呢個
This, well, Permanent Secretary, do you have, Deputy Secretary, do you have anything to add? Well, we will consider it in one go. But the principle applies across the board, is that right? As long as the transferee is not entirely Hong Kong PRs, then that would be the consideration for BSDs. Please show some sympathy because they're sharing a flat in a PRX unit. Well, I don't know how many such cases are there, but in this case, they've already been allotted PRX unit, and the flat can only be purchased by sitting tenants, not by anyone else. They are already sitting tenants. So they are allowed to purchase the flat. That means they're not taking resources from someone else. So from the perspective of combating speculative ideas, prices being pushed up by outsiders, that is not this case. Please give us a reply next time. Legal advisor, anything to add? I'd like the administration to clarify 29A and the policy intent. I ask this question because this is about an exchange of property. So there are two properties. Each party is both the transferee and the transferor. And the equality payment can be paid by either party. I don't know what the administration think. When it comes to an exchange between residential property and non-residential property, when one buys a residential property, there is no exemption, even if you are a Hong Kong PR. So excluding the fact about who is to pay the equality payment, when you buy in a non-residential property, it seems that it's a concession, because if the person buys with money, then he won't be able to enjoy a lower tax rate. Deputy Secretary. When it comes to exchange between properties and the equality money, well, we are talking about the DVD, which is an ad valorem duty. We want to double it. So the premise is the system of the ad valorem stamp duty. We're talking about an instrument, the same instrument. What rates is to apply for that instrument. And in the following provisions, you will see that we take into account the residential property bought in, because we're talking about demand-side management of residential property. So we will consider the transferee of the residential that will receive the residential property, whether they are Hong Kong PRs, whether they own other properties, and whether they are close relatives of the transferor. When it comes to exemptions and relevant arrangements, we would like to reflect it this way. After balancing out the tax system and demand-side management, we try to strike a balance with the exemptions. This is not about a balance. It's about consistency of policies. You have to specify who is to pay the equality money, then you can achieve policy consistency. If you don't specify that, then one party will be able to enjoy a lower rate. And if the equality money is to be paid by the transferee of the non-residential property, then he enjoys an advantage, because if he purchases it not by an exchange, he will have to pay a higher stamp duty. I just want the drafting to achieve consistency. Have you thought about this? Yes, we have. We're talking about the consideration, the difference. The difference between the values of the two properties. When it comes to the ad valorem stamp duty, the rate, the double stamp duty, the DSD, the nature is still an ad valorem stamp duty, and under this system, the payer can be either the buyer or the seller. So it's one of relativity. We have considered exchanges between residential property and residential, or residential and non-residential, or we want to follow the ad valorem stamp duty system, and it's for the parties to choose, and they have the duty to pay. We think this will strike a balance. Legal advisor. It means if you exchange properties, then you will enjoy a better position. There is some kind of is a better deal, because according to the new approach, the DSD, you can enjoy a better rate if it's an exchange of property. If you see it this way, it's different. But when we deal with these two provisions, we place the emphasis on the recipient of the residential property, because we're talking about a demand-side management of residential properties. And when we're dealing with the proposal of DSDs, we are aware that there is a tight supply of residential property. That's why we introduce some demand-side management measures. Under this policy, we consider that the transferee of the recipient of residential properties will see a corresponding arrangement. And when you are recipient of a non-residential property, as the legal advisor put it, it seems that that person will receive a different treatment as opposed to buying it from the market. But we're talking about the difference. This is a special circumstance and not a general case. Well, you can understand it this way. But you said in your reply that it's because of the consideration of 3B, because it requires that both of them will have, or all of them will have to be non-holders of any other residential property. But if they exchange a property, and if they don't hold a second property, then they don't have to pay BSD. Is that right? Yes. Mr. To? Let me think it through first. So a person owns a residential property and uses it to exchange for a non-residential property. In this way, he will enjoy a better deal than someone who purchased the residential to purchase the non-residential property with cash, because in the latter case, the double rate will apply, and in the former case, not. Is it because that there has already been the same approach in the IRD, or because of a policy approach? Well, foreign exchange is still the same instrument. What Mr. Stowe said is right. The recipient of the non-residential property is one party, and the other party is the recipient of a recipient of a residential property. And when we consider, well, we want to reflect the situation. And of course, if the person purchased a non-residential property in the market, but that person doesn't hold any property, then yes, the situation is different. But I'm talking about the value of the instrument is something completely different. If the purchase is made in the market, we're talking about the entire value of the instrument. But here, we're only talking about the difference in value between the two properties, and you have to pay the equality money. Legal advisor, how do you suggest that this be dealt with? My 2 cents is that when dealing with the exemption, that is, when dealing with the equality money, the transferee of the residential property will have to pay that equality money before exemption is given. And this will be in line with the policy intent of the administration. This amendment will not affect the relevant provisions in the 2012 stamp duty bill. Well, that is under the 2014 ordinance. It involves payment by purchasers. Well, I heard the legal advisor's point, but I've also pointed out that when it comes to application of DSD in certain cases, we use the valorum stamp duty system. It's just that in certain cases, we apply a higher rate. We will go back to study the point of the legal advisor. And if that is the case, then under the ad valorem stamp duty rate, both parties have the duty to pay stamp duty, but we choose to put the responsibility on a specified party. We have to look at it very carefully. Please do, Mr. Toh. Members of the public right to ask these questions. 3B. It says the person is not a beneficial owner of any other residential property. In a case, say for example, the father died, and they live together with, say, a few siblings. The will of the father states that the property will be equally divided among these siblings, among the children. Does it mean that the person has 1/5 of the non-residential, of the composite property? So that person will have to pay double the stamp duty, that is the DSD, right? You mentioned about a composite building, a composite property. Yes, that means someone can live in it, so in nature it is also residential.
佢擁有1/5嘅實益權益啦，咁佢其實都係就係入。
And if that person holds beneficial interest, 1/5 of the property, then it doesn't come under 3B. Let's say when the father dies, the will becomes effective. So when would that person be regarded as a beneficial owner? When is the interest vested? And if the person doesn't take out the probate for life, he doesn't becomes an owner.
你明白咧，就係最慘咧，就係有啲人咧，即係譬如個爸爸死又佢冇得揀嘅，大佬佢都唔想去。
Well, of course, the son has no choice as regards when the father dies, but this is a gift by the will. But suddenly, if he wants to buy a property, he would be subject to this. And sometimes the will has not been discovered. You know, there may be other proceedings regarding the will and the administration of the estate. Maybe it's a commercial unit in Shanghai Street.
好啊，
因為佢可能搞遺產承辦，佢搞到自己冇啊，即係搞到自己即係要退翻啦嚇。
Well, if the son doesn't want this? Maybe he's better off not to inherit that property's shares. Well, as Mr. To has pointed out, well, if he's a beneficial owner and through the will, he holds a fifth or a quarter of the interest, then he doesn't qualify under 3B. But whether the bill has been properly, or whether the probate has been properly completed, well, maybe the person doesn't know at the time of purchase. But legally speaking, when you purchase the property, you are regarded as a beneficial owner of another property. So in retrospect, he might think that it's better off for him not to have it. And the difference in duty may be substantial. But he has no choice. Maybe legally he becomes the beneficial owner once the father dies, at the very moment the father dies. 4A, do you have a definition of some close relatives? I think it's 3A. Yes, there's a meaning. 29 AD. Meaning of closely related persons is covered by the SSD and BSD. Mr. To, 4C, there's a magazine published yesterday referring to the 2012 stamp duty ordinance, asking for the oaths and declarations be made that the person is a Hong Kong permanent resident and he's acting on himself, not for any other person. Well, I think this is proper, but other members think that this is really silly. So in this case, do they have to make a declaration with regard to 4B? That is to say that they are closely related. 4C is reasonable. People may think, why do I have to declare that I'm a Hong Kong permanent resident since I hold a permanent ID card? But 4C is not about a declaration of permanent residency. So the question is, do you require a declaration to that effect in the 4C? And what about B? People may think that I can show you the papers or the birth certificate, and that the other person is my mother. Why do I have to declare that she's my mother? I've heard that there's a requirement to declare that one is acting for oneself and not as an agent for another. That's in relation to the 2012 bill now enacted. Because the stamp duty, the special stamp duty applies even a parent is who is not a permanent resident is acting on behalf of a child who is a PR. So the agent has to ask the buyer to make a declaration. But for BSD and DSD, we can check the documents to prove the close relationship. For example, birth certificate, marriage certificate, and other documents to prove that they are closely related. So for no declaration is required for 4B, if I understand it correctly. I think what you need is to have a declaration on 4C. If you are shown a permanent Hong Kong ID card, is that required to ask the person to declare that he is a permanent resident? Because the form that they are using states that the person should declare that he is a permanent resident and also not acting for any other else. But strictly speaking, holding a ID card with 3 stars, 3 asterisks, is not the absolute proof of the status. It all depends on the immigration status. Let's see. If you look at my birth certificate, you see that my name is Mr. To so and so. But the declaration was submitted by my mother, and she declared that Mr. To was my father. The birth certificate is not a proof of that Mr. To's status as my father, because the declaration was not filed by him. I don't know what you meant by closely related. If the mother has passed away and the person holds a birth certificate saying that another Mr. To was the father, it's not conclusive. Well, I've handled certain court proceedings. There was a misunderstanding that a certain person was the father, but he was not. Well, if it's the mother, of course, motherhood can be proved because the information was provided by the mother. But the information on the birth certificate is something provided by the mother. I just don't to avoid some comical situations arising from that. Madam Chair, we have answered the question on who are closely related. We'll look at all sorts of documents and whether the person is acting on his or her behalf. That's done through the making of a declaration. And in the declaration, he will also be asked to state whether he or she is a permanent resident. With regard to the declaration to prove 4C, is that a statutory requirement? There's no document or proof to show that, unless he solemnly and sincerely declares so, and the executive or the IRD takes it on that basis. Well, please be careful about relationships within the family. We have handled many cases. We have been dealing with the housing department. Some hold birth certificate, some don't. Some lost the certificate during the war. And they may not have any paper to support, to prove the family relationship. It didn't really occur to them that someday they will have to prove this. And the ILD may be just interested in tax, but the related persons might take it very hard. So let's say, for example, if you allow them to make a declaration to prove it, or they will allow some indirect proof be accepted by the ILD, that would be much more better. Because if you are strict, if you cannot prove it on a very strict basis, then they have to pay a higher duty. And also the term beneficial owner is a problem. There are court cases as regards who actually paid the consideration for the acquisition of the property. So problems can never be fully avoided. We can only be as prudent as practicable. I understand that in some cases it's difficult to tell who is the beneficial owner. But that will be settled after the court proceedings. But here you're talking. Are you talking about proof of the relationship between father and son, and the duty is substantial in terms of money? For example, if a person buys a property at $10 million, 4% is hundreds of thousands of dollars. I hope in applying this closely related test, you should be more generous, or maybe you should accept some prima facie evidence together with some indirect evidence and accept it. We have to be careful in the implementation. We have to think through everything, and the starting point is to have something objective to prove it. In special cases, if objective proof or documents cannot be located, whether there are supplementary evidence. In special cases like this, I believe the ILD will be able to deal with the cases carefully. Well, you are not ruling out what Mr. Cho is suggesting, since you talk about objective proof, whether they are father and son, whether they are a married couple, and you want to argue your case with the ILD. It's difficult because ILD thinks that collecting tax is the #1 priority. I hope you can give me a reply. How strict you are going to be, or what happened in previous cases. Otherwise, I would not accept the term closely related persons. Or I would suggest something like persons who can produce some evidence to prove the close relationship between them. If the two pretend, well, if they want to fake it, well, they may be already in their 80s or 90s. They might not have got married. It was during the war. They just try to escape together, and if they have to pay a higher stamp duty, hundreds of thousands of dollars more, then it's really hard on them. If you're very strict, then I would have to suggest a looser definition.
用一啲
We will consider the views and we will give you a written reply. I think you have to strike a balance. On one hand, you have to avoid charging double stamp duties in cases that do not warrant it. On the other hand, you will have to make sure that there is no loophole. 29AO. Also, the case of exchange between properties and certain instruments affecting exchange with ad valorem stamp duty. 29AO, exchange between residential properties. The parties both receive residential properties. So if they are Hong Kong PR and the beneficial owners of the new property and they don't hold other properties, then the arrangement applies to both sides. And if the parties are close relatives, then whether they are Hong Kong PR or whether they hold other properties, the old rates will apply. 3A is each party. Yes, because both of them are recipients of residential properties. Legal advisor. 29AP and 29AQ, they are also related. 29AP is in relation to closely related persons and an exchange of properties in the case of addition of names. 29AQ, close related persons and a withdrawal of names. When it comes to closely related persons, we have mentioned about the addition and deletion of names. Let me quickly go over the arrangement. In general cases, if they are closely related persons, in the case of either addition or deletion of names, the transferee, that is, of whom the name is added, if that person holds a property in Hong Kong, well, perhaps let me put it in a simple way. Under the current regime, addition or deletion of names between closely related persons, the conveyance, the agreement of sales will see them as the same person. So the instrument dealing with the addition and deletion and addition of names, exemptions will be applied to both old and new stamp duties. Under the DSD, since it targets people who hold another property, so if the transferee holds another residential property, then that person will not enjoy exemptions like he does currently. They will have to pay the DSD at the old rate. Say, for example, the wife adds the name of the husband, and the wife has another property. Then the husband will have to pay double the rate, the old rate. They are closely related, so the old rates apply. So if the husband holds another property, there is no need to pay the new rate. New double rate. No, this is under closely related persons. Yes, under the existing ad valorem stamp duty, addition and deletion of names will see an exemption. But by adding your name, and if you already hold one property, then you will be holding another property. And as a result, you will have to pay the old rate. Legal advisor. Using that example, if the husband holds no other properties, then does he have to pay? No. Whether he owns another one or not, he doesn't have to. If he doesn't hold another one, then the same arrangement under the existing system applies. So exemption of ad valorem tax and the DSD. Under the DSD measure, if husband holds another property, then the value of his share will be subject to ad valorem tax of the old rate. Yes or no? If he holds another property, then he has to pay. Otherwise, no. Mr. To. Well, I think, Chairman, you're clearer than I am. So without this bill, this 2013 bill, closely related persons, say wife, adds the name of husband, there is no need to pay stamp duty. Right. 2. Wife adds husband's name and then adds mother's name. There is no need to pay stamp duty, ad valorem stamp duty, because they are closely related persons. So for the first property, well, okay, wife adds husband's name and then the mother adds the name. The mother of the husband adds the husband's name to the mother's property. So it's closely related persons, no need to pay. And then the father of the husband adds the husband's name to the father's property. Closely related persons, no ad valorem stamp duty. And under the 2013 bill, because they are closely related persons, there is still no need to pay. Is that right? Well, under the 2013, wife adds husband's name. There is no need to pay. And then mother of husband adds husband's name. And since the husband owns half of the wife's property, then he has to pay he has to pay the old rate to half of the share he owns. Why? Under the DSD regime, we target people who already own other properties and they buy another property or acquire another property. They have to pay the new DSD. Well, in Mr. To's case, there is not another property because only his name was added. We're now dealing with the instrument of the addition of name and the rates apply to the consideration. If someone owns another residential property and through addition of names to different residential properties, that person in effect owns other properties. Under this circumstance, we have to deal with it. And under the existing ad valorem stamp duty, the arrangement of closely related persons will give him exemption. We have to deal with this. So if you're already a beneficial owner of another residential property and through addition you own additional residential property, your share of the additional property will be chargeable. This is to prevent people from having their name added and in this way owning more properties. So, well, for the first property, there is an exemption, and then for subsequent addition of names, you have to pay the old rate. It's not fair. Say, before marriage, the couple did not buy any properties, and after getting married, then a name is added. Then there will be stamp duty implications. We want to reflect policy intent on this. No, but the wife did not buy an additional property. It's just that after the wedding, the husband wants to add the wife's name to the property. Say, one, he has no property. Then the mother adds his name, and it's exemption. And then father adds his name, then he will have to pay the old rate to his share. And then the wife adds his name. Is it still the old rate to his share? Yes. Well, it's very rare that you have to pay half of the property. Well, the consideration is only half, because you own half of it. I don't think this should be the way. It should be as if there is no 2013 bill. Mother adds the name, exemption. Father adds the name, exemption. Wife adds the name, exemption. Son adds the name, exemption. I think this arrangement should be retained even with the bill. I understand that this is to combat speculative activities. But this group of people, father, mother, wife, son, they are all closely related persons. The addition of name is only an arrangement within the family. With the 2013 bill, this arrangement's changed. Half of his share, well, his share is subject to the old rate. In this way, then the parties involved, the son or the mother or the wife, would be reluctant to add the name of the husband. Instead, they will be encouraged to sell the property to someone else. I just think that the bill should not cause an effect that someone's behavior will change. Please keep it, otherwise I will introduce CSA. Mr. Leung Chi Chung. I want to get a better understanding. Well, what if the father wants to add the names of the 4 sons, and among the 4 sons, 2 of them own property, the other 2 no? So is it that the 2 of them will have to pay the old rate to the quarter owned by each of them? So, husband and wife sign the agreement of sale and purchase. Is it different from having the name added later? Please ask the question again, be quiet. So, at the start, wife owns a property and then adds the name of husband. Scenario 2, the 2 of them buys a property together. Is it different? So in the first one, Well, the two people buys a property. One of them already owns a property. Then the entire instrument is chargeable to the DST. What about the second case? The second case, the addition of names, is that they will have to pay the old rate, but only his share. Well, it's a very narrow definition of closely related persons. I think you have to consider whether to retain the old arrangement of exemptions.
主席，我覺得咧就即係喺呢個嘅剛才我即係請。
Madam Chair, in the scenario that I have raised for clarification, you can see that this is a loophole. If from the very beginning both are purchases, they have to pay DST, but after some maneuvering, they only pay the half of the old rate. It's much better than paying DST. So we have to read the provisions together, and we have to start from the existing regime. Actually, in the drafting process, we did consider different considerations. Perhaps I can lay out in greater detail the thinking behind it. Well, you have to elaborate a bit more. I think the legal advisor's proposed arrangement can save a lot of money. I've given thought to the scenario raised by the legal advisor. The two scenarios would create a big difference. Let's say the husband owns a property, and the husband and the wife purchase a property together, and the whole instrument will be subject to DST. I think it would be easier to understand that the husband is required to pay the DST for his share. But if they do something differently, I think if you refer to a real case, the difference can be very, very substantial. It's the double of the double duty. If it's 20 million, it's 4.75% duty. Originally, double rate is $1.8 million. And if the wife buys the property first, and then the husband's name is added, he will pay the 4.25% of 10 million. It's a big difference. It's just 400,000 something vis-a-vis 1.8 million. That's because you regard the purchase of the property by the husband as a second property. I wonder if this can be adopted. If it's a purchase from a closely related person, because you provide a concessionary arrangement for addition of names, so shouldn't there be a difference between purchase from a closely related person and from another person? Well, some people owns half a property as an investment, and now if he wants to buy a property for own use, it's a second property. I don't know whether the agents are very smart or they're really very smart. They're smarter than us. You know, there are many complicated family relationships. If you take a wrong step, you end up paying $1 million more, it could lead to the conflicts. Can you please reconsider? Legal advisor, well, I have nothing to add actually. If a purchaser owns no property, and then before completion of the acquisition, he or she adds another name, would that change the stamp duty? I take it that it doesn't really amount to another conveyance. Say in your example, the wife signs the SMP agreement. The wife owns no other property. The husband does own another property, and then at a later stage, the wife nominates the husband to take up the assignment. The nomination doesn't attract another stamp duty.
直情唔使俾添喎，係嘛？咪應該俾翻原本。係啦。
I think the original duty would apply.
我係即係證實翻法律顧問個睇法係。
I can confirm that the legal advisor's view is correct. If one owns no property, if the person owns another property, then the old rate will apply. Oh, wait a minute. Let's say the wife signs an SMP agreement, and after the mortgage is completed, when it comes to assignment, through nomination, there are two names. No, only the husband. The husband is nominated to take the assignment. All right, the wife nominates the husband to take the assignment. Okay, perhaps we should ask two questions. Either adding the husband's name or nominates the husband to take the assignment. With regard to the two cases mentioned by Mr. To, in the first one, if the wife, the lady is the purchaser, and before completion, he nominates her husband as the transferee to take the assignment. If the husband doesn't own any other property, there's no need to pay any duty. What if he owns any other properties? Well, and then the old rate is paid. In the second case, the addition of the husband's name confers half of the shares to the husband. So the old rate, half the old rate would apply. So that you must use this approach. Otherwise, the entire instrument will attract double stamp duty. I don't know whether the Bureau has briefed the real estate agents and related parties with regard to these examples. Well, we are ready to answer questions. I wonder whether they understand the rules fully. I don't know whether you have any justification, any provisions to justify the paying of stamp duty the second time. If he doesn't have any other property, what if he has another property? You are saying that they have to pay the second time at the standard rate or scale 2 rate. The wife signs the SMP, and then the husband is nominated. Then on what basis can we charge the stamp duty if the husband owes another property? You charge the agreement for the nomination. That's a chargeable agreement. But the husband and the wife are regarded as the same person. It doesn't matter whether he or she owns property. Maybe we should have all the cases set out in your response. Let's look at 28B. The rules are specified there. Apart from the AB table, in the ABD, if they don't own any other property, they are regarded as one person. Otherwise, under 29AP, the duty will be payable. Maybe you should make use of some slides, PowerPoint and briefing materials. If you have used the slides to explain this to the agents, can we be given the same so that we can learn something? I think it's not secret, but they have to do the briefing.
實有啊，一定有啊。
有啲乜嘢？
係有啲咩？係
即係有啲乜嘢就俾
你唔好特登做啦。
So you don't have to prepare materials afresh. Whatever you just want to get, whatever you have already got. It's a very complicated situation. I wonder if couples understand what to do to save money. Well, they have to get advice from the agent, or if the couple is advised to see a lawyer, then the lawyer will bear the responsibility. But you can only save duty, save tax if one of them doesn't own any property. All right, members have asked you to consider the different scenarios and give us a response. Well, 28P and 29AP and 29AQ are related to the additions of names of closely related persons. So we can give you examples with reference to the provisions here. Actually, after the bill is enacted, we're going to upload all the briefing materials to our website. All right. I would set out the cases in 29AQ. Clause 11 is simple. It's the heading. Division 3, agreements for sale, page 7, C723. Marked copy, page 30. Agreements for sale. Please continue. Clause 12 is simple. It's page 33. Left hand side, in brackets 29D, within the mirroring of section 29D6D. In clause 8, we already explained what this is about. It's a drafting presentation. Here we take out this because of the duplication. Here we're talking about agreements. It's a technical amendment. We'll move this to the section 29, and we add a subsection 8. Here we can do without this reference.
3咧
Clause 13 is under Part 2 dealing with the assignment. There are corresponding provisions, and under this division, the relevant provisions related to assignments are repeated here. So 29BA is Part 2 29AI in relation to assignment. 29BB is dealing with the arrangement of a Hong Kong PR and non-Hong Kong PR. You will see the mirror provisions in 29AJ. 29BC is 29AK under Part 2, that is related to exchange with closely related persons. 29BD is 29AL, dealing with replacement property. So these are the mirror provisions of Part 2. 29BE is 29AM, dealing with agreements of sale and purchase agreements of court pursuant to court orders. 29BF deals with exchange between residential and non-residential property. 29AO deals with exchange between residential properties. That is 29BG here. 29BH is the mirror of 29AP. That is the addition of names of closely relative persons. 29BI is the mirror image of 29AQ, deletion of names. So we will incorporate these consequential amendments to them. So the wordings are the same, basically, right? Yes. Please continue. Page 42, clause 14. 29, section 29C. The heading is made clear. This is in relation to general provisions on chargeable agreements for sale. Next is page 4. Is clause 14(2) in relation to 29C 5A dealing with general provisions on chargeable agreements for sale. We add subsection 5AB. This is page 45 in the markup copy. This is to cross-reference at if a person involving in a nomination of a close relative or acting on instruction and add and delete a name. This if the addition and deletion of names is seen as the same person, this is a corresponding amendment. IRD. Nothing to add. Page 4. Clause 15 is under the 29F, we add 29F, 29BF, and 29BG. '29 is in relation to an exchange of instrument of immovable property. The charging is done under 29 BF and BG, and that is in relation to exchange between residential properties and exchange of residential with non-residential. This is a cross-reference. So all the wordings are the same, right? Yes, 29 BF, 29 BG refer to exchange between residential properties and residential and non-residential. This is clause 15. We add division 4, conveyances on sale, further provisions. It involves further provisions of assignments. We expand the scope. Under section 29D, it involves not just residential property. There are references of non-residential property. So all the reference of residential property are substituted with the term immovable property to cover both residential and non-residential properties. This is to expand the scope to cover non-residential properties. Any questions? Legal advisor. Sorry, Deputy Secretary. I want to go back a bit to 29C. Exemption to closely related persons does not apply to non-residential property. (29C). Okay, now without the 2013 bill, closely related persons and an exchange with an industrial building, from father to son, is exempted from stamp duty, right? Deputy Secretary, perhaps I will defer to the IRD. So closely related persons, addition of names. Okay, addition of names. Son's name is added by the father, non-residential, without 2013 bill. That is the current regime. There is an exemption, right? There is a simple principle. All these exemptions apply to residential property only. So there has never been any exemptions. So for non-residential properties that include car parking spaces, right? Yes. So it's property plus car parking space. What happens? There will have to be different instruments. The car parking space is non-residential property. And if it's included in the same instrument, then it's considered as a residential. Yes. If it's separate, two different instruments, then you can only add the name to the residential property and not to the car parking space. Yes, otherwise it's subject to the DSD. Yes. In short, so there is no exemptions for residential properties of closely related persons under the ad valorem stamp duty system, right? Now, Division 5. Without 2013 bill, father adds the name of the son industrial building, then the son's share is subject to the old rate. With 2013 bill, son's names added by the father, then the entire consideration is subject to DSD. So addition of name is DSD for half of the share. Well, under Bill 2013, if it applies to non-residential, how come that when the son's name is added, is subject to is DSD? You mean in relation to non-residential properties? I don't understand the policy. The policy consideration is that we have taken into account the housing needs of closely related persons. That's why it's a residential property. Whether we deal with the DSD or BSD, well, for BSD, it targets residential property. And under DSD, this is also a policy consideration. I don't agree. Let's imagine. Yes, you want to target residential properties. Say a family business selling peanuts. Okay, industrial buildings, domestic operation of a factory. Why are they subject to DSD? It's closely related persons. Well, you can't create it. But if it's in-laws, yes, you can create in-laws. You can marry someone's daughter to avoid that. Of course, that itself is unbelievable. Say if it's a little repair shop, it's transferred to the son. Why is it subject to DSD? It's not right. I think DS? I think he wants to retain the old arrangement. Well, you want to impose a double stamp duty for deterrent effect, but the son has been working there from an apprentice. So the shop is transferred to the son. That's only natural. Why is it subject to DSD? Well, I think it's the arrangement is about exemptions or not, but this time it's about double the rate. Well, I can understand it if the old rate is paid, but you're not talking about the double the rate. Well, it will deter transfer of the business from father to son. It's just passing it on from father to son. It's not speculation. Let me explain. In relation to the in relation to the DSD, it applies to all immovable property, residential and non-residential. When it comes to exemption of closely related persons, we take into account housing needs. And we take into account whether the persons are Hong Kong PRs, whether they hold other properties, and whether they are closely related persons. So these three are the conditions to be considered before an exemption is considered to be given on the instrument. When we draft the bill, we have kept this in mind. Yes, I know. You can repeat it 100 times. I know. Well, consider it, otherwise I'll introduce CSA. Because this is not conducive to family harmony. You can't create a closely related person. You But you can create in-laws by marrying someone's daughter or son. So why don't you keep the old arrangement and let the old rate apply? Why double it?
秘書長，
I have nothing to supplement. Please consider and come back. All right, take this on board in your consideration. Maybe you didn't think about this in your drafting. Well, we did give careful thoughts to all of these. Okay, all right, but please consider it again. Legal advisor, are we on 16 bracket 6, immovable, substituting residential with immovable. 7, we take out the word residential, so only property is left. The term is property now. And there are also other technical amendments. We cross out the word residential, so it reads property. And then clause 16, bracket 10. And that is it's a 55 cross 16 bracket 12. We explain bracket 7. We add 29D. And we look at the instrument, whether it's a pursuant to a agreement and whether the person should be regarded as the same person. And that is to mirror the arrangements for closely related persons. Under bracket 7, we have A and B, and in B, if the assignment is made pursuant to an agreement, no SSD is payable. And since we have the BSD, once the bill is passed, we have to cross-reference to the Schedule 1, the reference of closely related persons in Schedule 1, Head 1, Bracket 1. We need to add a C to cross-reference Schedule 1 1C in relation to BSD.
係，俾繼續討議員你有意見係嘛？
唔係，我希望你，因為呢個太複雜，所以咧我希望。
It's really complicated. Legal advisor, well, if I'm not asking about your personal views. Please remind us about the points that we need to pay attention to. Legal advisor, anything? Nothing about bracket 7. All right. Please let us know if you have any comment to offer. 56, cross 17. Oh, sorry. We still have a bracket 8. Have we covered a bracket 8? Legal advisor? I want the administration to explain that after adding bracket 7 and bracket 8, what the purpose of doing this? I'll defer to my colleagues from the IRD. Mr. Tam? And here bracket 8 there's a reference to 29D, bracket 3, and under 3 an assignment may be the result of more than one SMP agreements. There are two or more SMP agreements. And then when it's what would happen when assignment takes place? And here we stated clearly that if the SMP was signed between some of them was signed before the 23rd of February 2013 and consignment happens later, and if the assignment the assignment arises from a previous SMP agreements, we look at the days of these previous SMP agreements and ascertain whether all stamp duty payable has been paid. We have some transitional arrangements. If there are documents signed before the 23rd of February 2013, then the new provisions will not apply to them. But under the 29D bracket 3, we'll have to consider all the previous SMP agreements.
即係唔好意思，我想即係了解一下，因為如果既然嗰個
If the agreement it was signed before this bill is enacted, the new ordinance is not applicable. We only trace back to the 23rd of February 2013. Anything signed before the 23rd of February should, in theory, not be subject to the DSD. That's not what you are asking for, right? We look at the previous SMP agreement and see whether stamp duty has been paid in accordance with the previous regime or the new regime. And we have to find out if stamp duty has not been fully paid in some cases. Can you give us a simple example why there are more than one SMP agreement? Maybe I can ask my colleague from the stamp duty division to give you an example. If there are two non-residential units and there are two agreements for sale, one A, another B, and then the one assignment covers both. If one of the SMP agreement was signed before the 23rd of February 2013, the other after the 23rd of February 2013, then in respect of B, a forum duty is payable but not for A. If we look at 71, Section 71.
陣間揭翻去7條嗰度咧，咁就
we have to go back.
係啦，咁佢就話咧呢個7條。
71 bracket 3. And that is to say, this bill does not apply to instruments signed before that particular date. If you look at bracket 3, so no duty is payable for agreement A, but B, it applies to B. Under this regime, we cannot ignore the first SMP. Therefore, in bracket 8 here, we set out clearly that we are going to consider Agreement A. To see if $100 stamp duty is imposed. And we look at the agreement, which is how the assignment is based. Legal advisor? Well, I understand the reply from ILD. I don't think this is necessary as a matter of law. Stamp duty is payable. The assignment is about 2 properties. One of them is subject to this 2013 bill. Property A hasn't paid, stamp duty hasn't been paid for property A. So the person has to pay a DSD for the second property. Well, you may think this is just an avoidance of doubt provision, but it's not absolutely necessary as a matter of law. Thank you. I think the example is clear. Let's say I take it that you're correct. It's not necessary. Would there be negative effects? I think the negative effect is that it's puzzling to the ordinary reader. They will have to get some help in explanation. If there's a need to explain in the future, well, we have many Q&As on our website. We'll clarify this. Have you completed your FAQs? Well, we are still adding more to the list. Well, I've been checking those as we move along.
好，咁就繼續啦。
All right, let's continue. Clause 17 is page 60. It's relatively simple. This is about the definition of transferee. In clause 8, we already add the definition there, so we repeat the same here. It's in another provision. Please continue. Division 5, clause 18. It's about redevelopment. 29 DE, relevant exemptions. It's under SSD, BSD. And that is in the case of buying properties for the purpose of redevelopment, and within 6 years, there will be a refund. We are going to follow the same provisions in the enacted 2014 bill. We are going to move a CSA to mirror those provisions on exemptions.
Yes. We will have put in the same arrangements as the bill endorsed in 2014. Next is, that is 29DE. 29DF is in relation to persons who have disposed of a property before acquisition. Previously, we have received some CSAs from members, and the latest one is from Tony Zhe. Mr. James To, Mr. Wong Ting Kwong have also mentioned about this. We will look through them and cover the issues involved and give an overall reply. We think that when it comes to disposal before acquisition and the refund mechanism is in place to ensure that there will be demand management of those who already have property. They will have to first pay the stamp duty to have it refunded later. And the date has to be set clearly. It's set to be 6 months. Members mentioned about special properties that are bought off-plan. Off-plan properties can be available for sale 30 months ahead of its completion. So when it comes to properties bought off-plan, how can we put this under the mechanism and not allowing too long a time for these persons to acquire property? We consider the occupation permit. We also consider the receipt of compliance certificates of compliance as time to count 6 months. We have to carefully go through the sales and purchase arrangements under property bought off-plan. When we are dealing with uncompleted properties, that is, properties bought off-plan, we have to consider the impact on completed flats. Members ask whether 6 months is an appropriate length and whether it should be lengthened in the case of flats already completed. We have to strike balance among different areas. We, of course, would like the provisions to be clear, consistent, and to have a definite period set down for the refund. We've had some discussions on this. DS, could you please consider this further? Mr. To. Well, I've just learned that under the 2012 bill, of course, for the 2013 bill, the rate is not as high. It's only a double of 4%. But there are cases in which some people use these ways to buy a property of 300 square feet in the name of a company and sold it to avoid 30 million stamp duty. That is in relation to redevelopment, yes. So it happens. Well, unless you really want to create such a situation, you have to consider changing it. Well, we're aware of the situation mentioned by Mr. To about restrictions on redevelopment, but now we're talking about we're talking about replacement properties. We've noted members' views. We've gone through members' proposed CSAs. We will give an overall reply. Well, in relation to redevelopment and 29 DF, disposal before acquisition, are issues that we will come back to. DS. Then it's 29 DG. This is to deal with the situation under 29D and DG, DF. In relation to refund, if the disposal has already gone through but the assignment is not yet completed, then the person will have to pay the ad valorem tax. This is related to 29DF. Any views? I have a question. Mr. To, does it mean that when it comes to replacement, BSD is about residential property, here is about non-residential and residential? Say to acquire a property is replaced by residential. What about acquiring an industrial building for a residential property? We are now finalizing the written reply. We will give you a reply, but we tell you that the nature of the properties have to be the same. For replacement properties under the DSD, if they are residential properties, and if another property, well, that means a residential property is to be replaced with residential, non-residential to be replaced by non-residential. And we also mentioned about redevelopment. What about composite building? If it's a composite building being resumed, you will insist that it is a residential property? If the one that is resumed is composite, residential commercial, say an office, so you will require the person to buy a composite property or either residential or commercial. I think you need to have some flexibility. Well, there are opportunities for us to discuss more about replacement properties. The DS agree that this is an issue that she will consider and give us an overall reply. This point may not be covered by any of the CSAs because this doesn't apply to the 2012 bill. I remember that none of the members mentioned about this. That's why I want an answer. Last time this point was mentioned, so we are now working on a written reply. The principle is that residential for residential, non-residential for non-residential. If it's a composite residential commercial, the IRD under the IRO sets out conditions and instruments. So the IRD will look at these conditions. It will also look at the title, building permit, deed of mutual covenant. So is it the case that you're looking at the finer details? What about general principle? Residential for residential only, non-residential for non-residential. But there are properties that can be used as either residential or commercial. Will you allow them to change it for purely residential or purely non-residential? So what is the arrangement under the original provision? The original provision states for non-residential, residential for residential. That's very clear. If it's composite in nature, then the IRD will have to consider the case by the conditions set down in IRO to decide whether the property is non-residential. Perhaps we will hear from the IRD. So the IRD will decide whether it is residential or not. If it's decided to be non-residential, the replacement will have to be non-residential. If it doesn't meet the conditions of non-residential, then it is residential. Then the replacement will be a residential. So the instrument will be the final. The final decision will based on the instrument. Yes, whether it says in the instrument that part of it or none of it should be used as residential. Whole or part of it is not to be used as residential. I just want to ask, well, if it fits half of it, that it really can be, if it meets half of the conditions out of the 4, then you allow them to get either residential or non-residential. Say 4 criteria. The title. Now, title says that it can be residential or commercial. And in each building, yes, residential or commercial. Occupation permit, residential or commercial. DMC, yes, for each unit, residential, commercial, and all the fire installation services are in place. So that means that you can use it for either residential or commercial. Perhaps you will give us an overall reply. Legal advisor. Based on the principle explained by the DS, for residential, commercial, if there is no prohibition for it to be used as a residential, then it is residential. So there is an inclination. So if there is no prohibition for it to be used as residential, then it will be classified as residential. Then there is a problem. So the only replacement can be residential, otherwise it's not treated as a replacement. It's problematic. You may say that in general, residential is more expensive than non-residential. No, that is not the case. Office space is can be very expensive. So if it's residential come commercial, and if you say that if there is no prohibition for it to be used as residential, then it's treated as residential, there will be a lot of cases of exceptions. Well, Mr. To has outlined a number of possibilities. Please consider them. A paper will be submitted afterwards, and I'm sure there will be opportunities for members, including Mr. To, to consider it. We're running out of time. So have we finished DG? Okay, well, we'll take it as we've finished DG. Next meeting is set tentatively on the 14th of April, 10:45. Please pencil it in. There being no other business, meeting adjourned. Thank you.
唔該。